Students, today's topic is capacity of parties from the Business Law, Chapter 4. Topic is capacity of parties. Capacity means legal competency of parties to enter into a contract. According to the law, contracting parties must be competent to contract. A person who is of 18 years of age or above and who is of sound mind and not disqualified by law are competent or eligible to form a valid contract. Opposite to this, the following persons are incompetent to contract according to section 11. A person who is minor, means whose age is less than 18 years, and who is unsound, and a person who is disqualified by law. A very simple and short description about the minor. Minor is a person who has not completed 18 years of age, or you can say a person whose age is below the 18 years. Under the Guardian and Wards Act, minor will attain the age of majority after 21 years of age, according to the Majority Act 1875. So, minor and person of unsound mind and a disqualified person are not competent to enter into a valid contract. This is regarding the capacity of parties. Next is nature of minors agreements, or you can say what is the position of minor under various agreements. The law regarding minors agreements may be explained as under. The first one is void agreement. Students say minors agreement is void because he has no capacity to contract. He is not liable to perform any act which he has promised. He cannot be compelled to pay back the money received by him. So you can say all the agreements made by the minor are void ab initio. Here is example on your screen. A minor sold his shop to B. The amount was paid to A, but the sale deed could not be registered as A was minor. On a suit by B, it was held that A was minor, so the agreement was void ab initio and the amount was not recoverable from the minor. So it is very much important for the parties when they are going to make an agreement with the others, try to check or see the capacity of the parties. Either parties are competent or not at the time of establishing or forming a contract. The next agreement, that is minor and ratification. Here ratification means confirming or approving the past act. An agreement made by minor cannot be confirmed by him on attaining the age of majority, because an agreement which is void from beginning cannot be made valid by subsequent confirmation. So minor cannot ratify his past acts which he has made during the minority. Make it clear? So a fresh contract is required on attaining majority, provided it is supported by fresh consideration. Here is example. M, a minor, borrowed some money and executed a pro note for it. After attaining majority, M executed a second pro note in settlement for the first note. It was held that the second pro note was void for want of consideration. So, minor cannot confirm his past acts which he has made during the minority. The next is minor and estoppel. So the law of estoppel does not apply on a minor, students. It means that a minor cannot be stopped from pleading his infancy in order to avoid a contract, even if he has entered into an agreement by falsely representing that he was full of age. So you can say the law of estoppel does not apply on the minor. M, a minor, fraudulently shows that he is of full age and contracts with N to sell his house. M refuses to perform the contract on the ground that he is a minor. N cannot sue M. So here in this example, you cannot stop the minor from showing his infancy, showing his minority, and you cannot compel the minor to complete his agreement. The next one is minor and repayment. A minor cannot be compelled to repay the money received by him under an agreement which is void ab initio. So once again, the agreement made by the minor will be void ab initio. You can say will be void right from the beginning. So if the money has been lost by the minor regarding that agreement, he cannot be compelled or cannot be made responsible to restore that money. Students, next is minor and necessaries. A person who supplies necessaries to minor can recover reasonable value from the property of minor. If minor owns no property, the supplier cannot recover the price of necessities which he has given or which he has provided to the minor. Minor is not personally liable. It is his property which is liable if he has. A necessary article depends upon the status and circumstances of minor. Luxury goods cannot be regarded as necessaries. Food and clothing are necessaries to the minor. Here are a few examples. A supplies necessaries to B, a minor, for his life. A can recover value from B's property if B has some property, otherwise not. Second one is A supplied a coat with diamond buttons to minor. A cannot recover the price of coat because the coat with diamond buttons is not falling under the categories of necessaries. So it is just luxury. For such luxury, A cannot recover the amount of such coat having diamond buttons from the minor's property. The next one is agreement by guardian on the behalf of minor. A contract from minor by his guardian is binding on minor. Once again, agreement made by guardian for the minor on the behalf of minor is binding. It can be enforced against minor provided it is written or within the authority of guardian for the benefit of minor. Example, a contract of sale of immovable property by the guardian of minor for the minor's benefit may be enforced by either party to the contract. So any agreement made by the guardian on the behalf of minor under the authority of guardianship, that agreement of guardian is enforceable and will be binding on the minor. Next is minor can be a promisee or beneficiary. Any contract for the benefit of minor under which minor is not required to bear any obligation is valid. So the agreements where no liability falls on minor will be valid, otherwise not. Minority of one party does not affect the other party's liability. Example, students, a minor advanced some amount to B. A mortgaged his property in favor of A. A minor can enforce the mortgage if B does not repay the money. So in this case, when B fails to return the amount to A, who is a minor, A can enforce the mortgage of that property and can refuse to return that property to B until B pays that amount. Next is minor as an agent. A minor can be an agent. Very simple, a minor can be an agent. If a minor works as an agent, he can make his principal responsible to third parties for his acts. but he cannot be held personally liable for negligence or breach of duty. So simply speaking, you can say minor can act as an agent of his principal if principal is agreed to accept the agental services of that minor agent. A appoints M as minor as his agent to sell his house. M makes an agreement with B to sell A's house. This agreement is valid. Next is minor as partner. A minor cannot become a partner of a firm. You can say a minor cannot become a regular partner of a firm. He can just be admitted only to the benefits of the firm through his guardian with the consent of all the existing partners. Minor can inspect the accounts only and not the books of the business. He cannot participate in the management of the firm. The minor's liability is limited to his investment in the business. ABC are partners in a firm. They make a contract with X, who is the guardian of M, a minor, to make M as a partner. M can be admitted to the benefits of the firm. The next one is surety for a minor. In a contract of guarantee, if adult stands surety for a minor, the adult is liable under the contract, but the minor is not answerable. The adult is responsible because there is a direct contract between adult and third party. Here is example. M, a minor, makes a contract with X. S stands surety for M. The contract is valid. The next one is minor as a member of company. A minor cannot become a shareholder of a company. Being incompetent to contract, a company can refuse to register, transfer shares in favor of minor unless shares are fully paid. So where their shares are fully paid, their minor can become a member of a company, or a company can transfer the shares to the minor as a member. Example, A has fully paid up shares in a company. He dies and leaves M, a minor, as his legal representative. The company is bound to transfer the shares to M. The next is minor and insolvency. Here minor cannot be declared insolvent because he is incompetent to make a valid contract. So when he is not competent to make a valid contract, how he can be declared insolvent by law? Even for necessaries supplied to him, he is not personally liable, only his property is liable. If he has no property, he cannot be asked to pay the amount, or you can say the amount cannot be recovered. Example, M, a minor, buys medicine from X. M has no property. M cannot be held liable for payment. He cannot be declared insolvent. The next one is contract by minor and adult jointly. Where a minor and an adult jointly enter into an agreement with another person, the minor is not liable. Only the adult would be liable, who is making jointly agreement with the third party along with minor. Example, M, a minor, and A, who is definitely major, jointly make an agreement with X. Here X is third party to purchase a car. The agreement is valid. The next is position of minor's parents. The parents of minor are not liable for the agreements made by the minor. The parents can be held liable if the minor acts as an agent of parents. So where there minor acts as an agent of parents, there the parents are responsible, otherwise not. Example, F sends his son M, a minor, to buy goods from S. M buys goods from S. F is liable for payment because here minor M is just representing his parents and going to the S for purchase on the behalf of his parents. The next one is minor and negotiable instruments. A minor can make, draw, endorse, and deliver negotiable instruments to bind the other parties except himself. He himself is not liable, but all the other parties would be liable. Here is example. M, a minor, draws a bill of exchange on A. A accepts the bill. M endorses it to C. The bill is valid. So students, this is all about the position of minor under various agreements. Students, you will get the videos regarding sound-mindedness and not disqualified by law from the main topic of capacity of parties in the coming days. Stay tuned. Goodbye.